The High Court has been asked to dismiss the challenge to the legality of the Natural Resource Fund Act brought by Opposition Chief Whip Christopher Jones. This call was made by Attorney General and Minister of Legal Affairs, Senior Counsel Mohabir Anil Nandlall, during the first calling of the case before Justice Navendra Singh on Friday. Prior to and following the passage of the NRF Act, government has continuously stressed that it emphasizes transparency and strengthened oversight of revenues for the oil and gas sector. The Attorney General said in the affidavit filed that the actions of the opposition is an abuse of the process of the court, noting that the challenge to the act is without basis or merit, adding that the case should be dismissed. One of the claims being made by the opposition is that there was no consultation on the formulation of the act. However, the Attorney General said consultation is not required for lawmaking. Nonetheless, the minister said while in opposition, the now government held consultations throughout the country, which then formed its manifesto.
It is that manifesto upon which we campaigned for the 2021 elections and upon which we were elected. That campaign consisted of hundreds of public meetings, 9 national rallies, and thousands of smaller meetings across the length and breadth of Guyana. If that does not constitute consultation, well then I don't know what is. Because it is in those meetings that every aspect of our manifesto would have been discussed and consulted upon.
The opposition is also claiming that the mace must be in place for a law to be validly passed in the National Assembly. It was pointed out by the Attorney General that there is no conditionality that says that the mace must be in place before a law is made.
In other words, Parliament lawmaking powers have nothing to do with a mace being in place or a mace not being in place, or not a right mace being in place or a wrong mace being in place. Those are not powers those are not things that affect the lawmaking power of a parliament. In any event, the standing orders themselves do not mention a mace. The word mace is not even in the standing order. So the argument that the mace was not in place or the right mace was not in place when the law was passed is a completely unmeritorious and specious argument.
The Attorney General rubbished the claims by the opposition that its members were not afforded the opportunity to speak on the NRF bill. That claim is described by the Attorney General as erroneous and fundamentally flawed.
Fortunately, the world saw it and we have it on video. They prevented the minister from speaking. They behaved in the most vulgar and riotous manner. They blew whistle, they chanted, they descended into the well of the parliament, they were shouting loudly, they grabbed the mace, they tried to pull it away, they broke it in the process. One of them ran into the control room and disconnected the mic. All of that is in the affidavit. And then they walked out of the parliament.
During the first calling of the case, several dates were set by Justice Singh for the submission of affidavits from the applicants and the respondents. Justice Singh also granted an application brought by attorneys Kamal Ramkaran and Says Gunraj for an extension to allow for Speaker of the National Assembly, Manzoor Nadir, to file his affidavit of defense.